quickly to Fiona Alexander, who to say thank you. She agreed recently to step in sort of short order as the original moderator had some other things that he had to attend to. Fiona's here at American University over on main campus, has been extremely involved in internet governance matters for quite some time and a long career at the Department of Commerce in these matters. But without further ado, Fiona, I'll turn it over to you to take control of this panel. Thank you.
Take control. It's kind of my normal way, isn't it? Anyway, thanks, Gary, for the introduction, and thank you guys for sticking around. As Gary said, my name is Fiona Alexander, and I did work at the Commerce Department for a long time, maybe 20 years or so. And I do a few other things now, including spending time up here at American with our Con Cyber and Economic Security Institute, as well as the Internet Governance Lab that we have here. But today I'm here to see what we can find out about what is a kind of a hot topic. And thank you for sticking around for the last session. I know sometimes it's hard to stick around to the end of the day. But I can guarantee you that you won't be disappointed from this conversation for those of you that are really interested in cybercrime. We're going to hear directly from our 5 speakers now that were involved in these treaty negotiations in one capacity or another. And then we're going to hear about the why we have this treaty or this draft treaty, the good, the bad, and the ugly about the process and the outcome. And then we're going to open it up to questions from the floor. I know Mike Nelson's going to have a question because he always does, so I don't have to prompt him. But everyone else could think about what question you want to ask when we get to that portion of the session. So I'm just going to briefly introduce our panelists, and then we'll head right into it. I'll do them in the order in which they are seated. So to the left is Nick Ashton-Hart. Nick was the head of delegation for the Cybersecurity Tech Accord to the Cybercrime Convention negotiations, and he's the senior director for digital economy policy for APCO. Nick participated in all formal rounds of this treaty negotiation, as well as the many unofficial side meetings throughout the process. Next to Nick is Will Hudson. Will manages the team of lawyers at Google who provide advice on criminal and civil society data disclosure requests from non-US and non-EU jurisdictions. He has participated in the UN Cybercrime Convention negotiations over the last several years as a delegate for various industry trade associations. And Will is a former US government person as well. There's several of those on this session. Next to Will is John Lynch. John is the chief of the Computer Crime and Intellectual Property Section, or CCIPS, in the Criminal Division of the Department of Justice. He supervised the CCIPS attorneys negotiating the convention, and he directly participated in the latter stages of the negotiation, drawing on his experience negotiating and implementing the Budapest Convention, prosecuting cybercrime, and formulating cyber policy for the last 25 years. Next to John is Pavlina Pavlova. She is a Share the Mic Cyber Fellow at New America in Washington, D.C., and she's leading research on gender consideration in cybersecurity and cybercrime. And she participated in the cybercrime negotiations as part of civil society feedback and part of the process. And last but not least on our panel is Ian Tennant. Ian represents a global civil society organization dedicated to analyzing and responding to transnational organized crime. Ian has been following negotiations since before they actually started, so we'll have to hear that story from him, having been a part of the UK's delegation to the UN ODC in Vienna for 5 years. So as I said, it's a really expert panel, and I know there's been a lot of conversation in the last couple of weeks on the Cybercrime Convention and the draft treaty and what happens next to it. So it's a real privilege to hear from the five folks from a wide variety of stakeholder groups, which is great, of their experience in this process so far. So the first set of questions I think we want to get to is, why do we even have this treaty? And a lot has been made about the idea that the convention originally, the idea of this convention came from Russia. So, and that actually feeds the topic panel, which is the UN Cybercrime Convention. Russia's Trojan horse is how this has been labeled. So we want to kind of dig into that a little bit. So what's the history of this convention and what processes were used to develop it? And we're going to turn to John to kick off and get his perspective on that.
Okay, thank you. I appreciate the opportunity to talk to all of you. And so the genesis of this convention goes back quite a while. Debate in the UN had been building up to a cyber treaty of some sort for some time. Cyber topics had been raised in the General Assembly, other UN bodies like the ITU and various committees of the UN, including the third committee, which is the primary law enforcement committee, and the first committee, which handles political and military affairs, among other things. Cybercrime had also been discussed in the UN Office of Drugs and Crime in what was called the Intergovernmental Experts Group on cybercrime for more than 10 years. And we had fully participated, including through my office, in these efforts, and established itself as a kind of leader and standard setter in that body. None of the early processes resulted in consensus on the need for a UN convention on or instrument on cybercrime. But as the discussions progressed over the late part of the 2010s, a growing number of countries, particularly non-aligned states, began seeking a UN cyber convention, and we'll talk about some of the reasons behind that, I'm sure. Russia did propose a resolution in favor of drafting a convention in 2019. It ultimately passed in the General Assembly by a plurality vote in December 2019. Russia, China, a number of their like-mindeds, and a number of non-aligned states voted in favor. The United States, EU, a number of our like-mindeds voted against. The vote meant that we were on a path towards elaborating a convention relating to cybercrime, and the United States judged this as preferable to efforts to do an information security convention in the first committee or in the political military sector. So we accepted the reality that one would be elaborated, and we went back and tried to make it as good as possible. We got, for example, stakeholders to attend and participate. We secured primarily a consensus-based process with voting that if it needed to have votes on substantive measures, it would be a 2/3 majority. We also internally came up with our key objectives for negotiation, narrowly tailored to cybercrime, consistent with existing treaties, consistent with US law, require only limited changes to legislation. And we hope that would get us to at least a well-informed consensus-based solution. And we encouraged, again, the participation by industry, by civil society. And over the next 2 years, we were in the process of developing the methodology, setting up the ad hoc committee. As all of you remember, we then had a pandemic, and that kind of delayed things for a little bit, but negotiations started in 2021 and continued for about 3 years, finally concluding in the beginning of August of this year. As negotiations started, we worked with our partners from the Budapest Convention members, some even non-aligned states. We had put forward a draft. Russia had put forward a draft. The US draft was primarily used as the basis for the treaty. That meant the Russians were in the position of having to argue for the changes. Also, a geopolitical event that affected the negotiation was the Russian decision to invade Ukraine in 2022. That put Russia on the back foot to some extent throughout the negotiations. And we used that fact as a reason to point out the problems with the Russian approach. It also allowed us to make the argument against what Russia wanted, which was a broader information control treaty, and we wanted to keep it more focused. Negotiation proceeded over the next 2 years, culminating in two final 2-week sessions, one in February, which was supposed to be the end, and then it got extended, and we did another session in August, both in New York, and that after that, there was at the end of that, there was a series of votes that Iran called on a number of the human rights provisions of the section of the convention. And Iran, although it needed 2/3 majority, in order to carry their votes. They were not able to get anywhere near that. In fact, the margins were about 2/3 the other way. And in the end, the United States delegation, of which I was on, we determined that we had concluded a document that fit within our negotiating authority. We recommended up to our supervisors that we join the consensus on the convention, which Iran, Russia, China, EU, and all did. That just means that it will now go to two additional steps. There's two standing committees at the UN, the third committee and the fifth committee. Fifth committee handles fiscal matters, and then it will go to the General Assembly for consideration for adoption in probably December of this year. If that's the case, the United States would then have to make a decision. It would open for signature probably sometime in 2025. And we would have to make the decision whether to sign or not sign the convention. And then after that, submit it to if we did sign, submit it to the Senate for its advice and consent on ratification. If they gave that, then the president at the time that happens would have the decision to ratify or not ratify the treaty. So those are going to play out over the next several years. It took 5 years for the Budapest Convention to get considered and ratified. So I don't know that that's going to be a quick process, or I don't think it's going to be a quick process. That's essentially where we got to where we are.
Thanks, John. I know, Ian, you had some perspectives that you wanted to share about the pre-process and then the current process. So I'll turn to you.
Thank you. Thank you very much, Fiona. Thanks, John, for the summary. I think from my perspective, having followed this from Vienna, where the UN Office on Drugs and Crime is based, where I was a member of the UK delegation, before this came about, I would disagree with the characterization of it being a Trojan horse. I think it was quite obviously a Russian horse at the beginning. It's now turned into a UN horse, I would say. But I think this is a culmination. I mean, John talks us through the processes, but this is a culmination of broader Russian strategy at the UN. Firstly, on cyber, where they're trying to kind of instrumentalize the UN to get more control over the information space, as they call it. This has been discussed earlier today, but it's also part of their general strategy at the UN to disrupt, to confuse, and to divert resources from what's really going on. And when I talk to people, it's quite difficult to explain to people what my job is. I've got an NGO with a really long title. And I say, we're going to New York because Russia has proposed a cybercrime convention. People think I'm crazy. They say, what? And from the work that we do, this is a state which is deeply enmeshed with organized crime in every single way imaginable, including cybercrime. And the audacity of it is quite breathtaking. In fact, that they would go to the UN and do this, but they did. Those of us in the delegations who are members of the Budapest Convention that's been mentioned in Vienna over those many years since 2010, when it first appeared, the idea of a convention first appeared in a UN document, did everything we can to try and delay and stop this process because we could see what it was, an attempt at control and a risk for human rights. I don't want to draw any direct correlations, but as soon as I left the UK delegation in 2019, then the process for a convention started. So I won't blame my successors, but in 2019 they'd had enough of the tricks and they tried to get it through. They'd got more support, as John said, and I think this is an important point to remember, that it's not just Russia that wanted the convention. It was a BRICS initiative, actually, for many years. So Brazil, Russia, India, China, South Africa. They didn't necessarily want the same type of convention, but they wanted a convention that's very important for capacity building, technical assistance, and kind of bridging the digital divide. when time had been exhausted in 2019, that's when Russia had enough, and they took it to a vote, and they won. And I guess the rest is history, and we'll discuss on the panel.
Thanks for that. And I think as personally someone that had to sit in a room in many windowless conference rooms, not as nice as this, and say no to Russia proposals for treaty for at least 2 decades in the ITU, it's a bit of a shock to see where we are today, but that's why it's important to have this conversation and understand the decisions and the choices that were made. So I think our next round of questions, I want to hear from everybody on the panel, but I think the question is this cybercrime convention needed? Why or why not? And I think, John, I'm going to start off with you, and if everyone could give kind of a brief intro comment as to why you think the convention is needed, and then we'll hear from everybody from their perspectives. But because the U.S. has been participating actively and celebrated the success of the drafting group, I want to hear from John as to why you think it's needed.
Okay. Although I'm going to push back at the question a little. I think from our perspective, it's not whether it's needed or not. It exists. It's a thing that was negotiated, and countries are going to join it. As you heard from Ian, this has been something that a number of countries have been pushing for outside of the Russia, China group. There is the Budapest Convention. The United States was a proponent of that. I helped negotiate it. But a number of countries, particularly in Africa, Asia, the Caribbean, South America, expressed that they were reluctant or unwilling to join Budapest. And so it was not negotiated with them, and it was at a place, the Council of Europe, that does not have entirely happy relation sort of associations for every state. So from my perspective, and I won't go into this, I want everybody to have a chance. From my perspective, the question is whether, given that it exists, we're going to continue to be a leader in the multilateral space for rights respecting or cooperation on cybercrime, or whether we're going to step back and allow this to be run by Russia, China, and their like-mindeds. So I think we should stay engaged. That has been my argument within the U.S. government. And I think we can continue to put pressure on the Russias, Chinas of the world to make sure that we do keep it a rights respecting convention. So I'll leave it there.
Thanks. Why don't I go to Will, then we'll go to Nick. Will, what's your perspective on whether this is needed or not?
So let's see if I can talk. Okay. So first of all, thank you for moderating and for it's a good opportunity to talk about this with a group of great folks. I think sort of similar to John, I'll push back a little bit on the question in the sense that, like, I think for me, the question is like, what is the problem this convention is trying to solve, right? I think it is undoubtedly true. It is undeniable that cross-border cooperation on serious cybercrime is a significant issue, right? It is complicated, it is messy, it takes too long. There's not dual criminality in cases where there should be. And the convention does do some things to address some of those issues. That I think is also not in dispute. The question is, like, the Budapest Convention and other multilateral processes also address that problem. And to John's point, I think it's certainly true, and I've seen it myself, where there are countries that have, for whatever reason, hesitation about joining Budapest, given that it's a Council of Europe document. My experience over the course of the negotiations was actually that's been tempered somewhat, and that countries that, once they got to actually engage with the text of Budapest, which is mirrored in some respects in the convention, they became more comfortable with it. And the deviations from Budapest, I think were more explainable in those cases. So from my perspective, I think that, it's not clear to me what the near-term problem is that this is going to solve, given that the U.S. would need to be party to it in order for the sharing of digital evidence component to be meaningful. And I think even in best case, we're looking at that process taking, as John said, a number of years. I measure this treaty in the time of, I started it with 2 daughters and I ended it with 3. I don't know, my 529s hesitate to venture what happens at the end of US ratification. But I think, the problem is real. The problem is getting worse. Serious cybercrime is a significant issue and people need help now. And this sort of relatively untested treaty mirroring an effort of something that is already in place and is already working well. To me, I question the utility of that. But
Nick, what's your take?
I would agree with Will, and I would say the demander question is an important one. And in reference to something John said, I don't think we should be in any doubt here. There's not a question of, well, we would either get a Russian information security treaty or we would get this treaty, because that's not actually a deal that was on the table. That's not the way Russia works. There is no doubt we are going to end up with an information security treaty. So what this is, it's not about cybercrime for them, because they don't actually cooperate on criminal matters with other countries, as far as I'm aware. It was a way to get a non-consensus treaty-making process agreed and get an instrument through it for them. That's what this is, because what they really want is a non-consensual treaty-making process on information security. And they've made it clear that that is what they want. So I agree, it's not a Trojan horse, it's a Russian horse, and it always was. And yes, it is true. Will's exactly right. There really is a problem here to be solved, but I experienced the same thing he did, because I spent most of my time with developing countries who do not have an easy way of cooperating now with key countries which have the data that they need. And they want, there's many countries who have a bona fide interest in actually cooperating. They were pretty skeptical about Budapest, most of them, because they were not a part of negotiating it. But the irony is by copying and pasting and then mangling a number of Budapest provisions, they started to see the origin as a better agreement because of the issues that they could see that were going to happen from the mangling of the provisions and then the adding of the Frankenstein's monster elements of copying and pasting from provisions of other conventions on top of it. So I think, and you see this, I think you can see this in the number of states who have applied to become part of the process of joining Budapest has spiked very considerably during the course of this negotiation. I remember a conversation with the delegates from Mozambique, actually, on one of the first negotiating sessions. And they were there and said explicitly, we want to cooperate more. And we see this as a possible way, but we're also exploring Budapest. Well, they'd been announced by the end of the negotiations as joining Budapest. And we told them, they said, well, we just realized we will get much more cooperation much sooner if we just join what already exists. And I said, well, what do you think of this? And they're like, well, we only got so much legislative time. We're probably not going to join multiple treaties that have an overlapping subject. So I think the best thing that could happen is that this treaty clearly doesn't have any data that anyone wants, because what they want is Western data. If countries find that they're not going to get that, they're not going to join it. And do we care if the world's totalitarian states have a private agreement to not share data between themselves? Because they're not looking for each other's data.
Oh, you put it that way.
They want somebody else's data. And they've been very open about that. Egypt and some of the other countries that were very active were very clear that it was US data that they wanted. And they're also very clear, like they would probably never be allowed to join Budapest. They couldn't get past the threshold of unanimous vote of the Council of Europe and then a unanimous vote of the rest of the parties. So it's a kind of long way to answer the question.
No, it's helpful. Let's go to under the table. We're from Pavlina and from Ian. What's your take on this? Is this convention needed? Why or why not?
Thank you very much. And thank you for having me. It's always a pleasure to be in a good company and to discuss important conventions. So I would just like to hit several points, starting from your first question. What was the process? And as someone who covers both cybersecurity and cybercrime negotiations, and some other connected processes, we definitely see that Russia has a long history of proposing conventions and instruments, kind of overwhelm the system, push for its interests in a very selfish manners. So it's not about negotiating any public good treaty in the first place. As such, these treaties are filled with proposals on interests, and we definitely will see a push also in the first committee on peace and security matters at the United Nations, using this success story for them, having United Nations Cybercrime Convention to push forward all their proposals for cybersecurity convention, which then undermines the normative framework which we already have for state behavior in cyberspace. So it's important when we discuss Cybercrime Convention to also understand that there are certain states with capacity to push buttons in different fora in a very organized manner, and never take it only as a piece, because it's a whole puzzle. And who pushed for the treaty to have it? Who were the proponents of the treaty? It was mentioned it was BRIC countries, so there is a bigger global, even cross-regional interest. But who also voted in favor were Russia's geostrategic allies such as China, Iran, and North Korea, all of which we know that they are harboring cyber criminals massively. So this comes as a very uneasy start to the treaty, hence the name also of today's panel. And the mutual priority was something that was bothering them very much about Budapest Convention, and it's having very strong provisions for expansion of digital sovereignty. So states voting against or abstaining said that there are regional and international instruments already in place. And we mentioned a lot Budapest Convention. Was mentioned also that the existing documents is based heavily on Budapest Convention. It just so countries actually eventually may join both if you join one as well. But the context for it is different because the parties to the treaty are different. We also have Malabo Convention of the African Union. We have UNCAC and UNTAC as UN instruments, which were mentioned repeatedly during the negotiations. So it's a good question whether a convention is needed, and also whether it gives enough of, especially mentioning as one of the key elements of the treaty and purpose of the treaty to protect cybercrime victims and witnesses of cybercrime, whether it really delivers as an instrument, because those two provisions are very watered down in the final document. But on like more balanced picture of the convention, it depends very much who you ask whether the convention was needed. And we heard already about the many interests in these negotiations. It very much also depends on, do we need the convention? Depends what convention are we getting. So if we are getting narrow scope, which we are not exactly getting right now, it was argued that as it can be effective instrument, as it is now, it may overwhelm the system and also data custodians and further frustrate the data requests between private companies and states, which are already problematic, as mentioned by several speakers before me. But at this heart of this convention, it's intended to allow for law enforcement from different countries to align their capacity building needs, their provisions, the legislation, and set out to prosecute, investigate, and prevent cybercrime. And as such, not to forget, even before it becomes, if it becomes UN instruments for which it needs 40 ratifications, it already has a normative power as such. If it's agreed, which I mean, I believe it will be agreed, adopted by the United Nations General Assembly in December this year. It already has this normative power, and it already started. It was also discussed by earlier in other discussions by the negotiators, including the United States, that it has already having these parties negotiating together, needing every single vote because it could go into votes, which didn't. So it is a consensus document right now, not to forget. It already starting important discussions about what the law enforcement agencies need in the countries, what are their capacities, what are their practices, how they can exchange better. So the normative kind of effect of this treaty already started even before it's being adopted, ratified, and implemented as such. My final point being that while it unveiled a lot of friction between countries, whether and it ended up only with minimal safeguards and human rights provisions, which allow international cooperation. This is something very unfortunate. On the other hand, the treaty's effectiveness and whether it will do more good than it can create harm hinges on the implementation. So the whole focus of this discussion, as the treaty has been agreed by consensus in the committee, it needs to be confirmed, but it has been adopted by the committee which negotiated it, is very effective oversight and engagement of stakeholders. So hearing from those countries who want to kind of monitor the implementation and seeing how it's going to be instrument for good to support this argument, they need to follow the words with action and support very strong oversight engagement from stakeholders, including NGOs, including broader civil society, technical experts, and of course, private companies.
Ian, do you have something to add, or can we go to the next question? Or do you want to make sure you add this one?
Let's make two quick, very quick points. The first is, mainly agreeing with the others. Yes, there is a need. If you look at the scale of even some of the core cyber-dependent crimes in the treaty, it's clear that we're not doing enough at the moment. We look at fraud, ransomware. The second point I want to raise, just to respond to Nick's point, is on the risk of letting the group of kind of totalitarian states kind of run off with the treaty, as it were. It's not their own treaty, it's a UN treaty. And it may be, convenient for private sector if they're not operating there, but for the civil society and people, journalists, researchers in those countries who could be affected by evidence sharing, information sharing, mutual legal assistance, even extradition under the treaty between those countries, which may take place anyway, but now would be done under the UN flag. That's the reason why the monitoring of the implementation, as Pavlina was saying, is so important.
Thanks. And I think, look, I'm much more of a tourist on this particular treaty negotiation as opposed to other treaties that I've been involved in. So I know how challenging the processes can be, and I know how difficult it can be just inside the US government to get all the different facets of the executive branch on board to negotiate a treaty. But it does seem to me this is a little bit unusual because there's a cadre of people that are not happy at all with this draft text that's been agreed by consensus out of the committee. And to be clear, it goes to the General Assembly for a vote. Then the United States has to decide that it wants to agree to it. Then Congress has to ratify. And for those of you that don't know, congressional dynamics is a Senate vote. So the US Senate has to vote it up or down. So the fact that you have a wide variety of US stakeholders very unhappy makes me wonder whether the US would ever ratify a treaty, but you never know. But it's interesting to me that you have the International Chamber of Commerce, you have the US Chamber of Commerce, and I think over 100 different civil society organizations signing a letter all saying they don't support this treaty. They think that it doesn't have strong enough provisions for human rights. They think that it impacts negatively cybersecurity researchers and journalists and people like this. And then one of the other things that was a little bit striking to me in particular, as we've talked about it, how it compares to the Budapest Convention, is that Budapest, as I understand it, again, I'm not the expert, that's why I'm going to ask these guys this question, does contain certain provisions of having a domestic rule of law component to sign on to the Budapest Convention, which brings its own suite of safeguards and implementation. And this treaty will not have any of those rule of law requirements. So that's causing some of these concerns. But if I could hear from, why don't we start with, we'll just go straight down the panel about some of the concerns that people are raising, and they're raising them pretty loudly as far as I can tell, whether you think shared those concerns, if you're part of the community that has those concerns. And if you don't agree with the concerns, it'd be great to hear as to what you think the answers to those communities of interest are. So why don't we start with Nick?
Sure. I could spend a very long time outlining all of the things that are a problem with this convention. So there's not really enough time, but we were part of industry participating in the whole negotiations. And I've been involved in international negotiations for most of 25 years, and I have never seen the private sector and all of the NGOs aligned across the board in an entire negotiation to the point where at one point, my colleague and friend at Microsoft, in one of his formal statements to the committee, said that he could trade statements with any of the human rights NGOs in the room and read them without modification. So you have to imagine, if you're listening and all of civil society and the private sector are united in saying you're wrong, that you have a problem. You have a serious problem with what you're doing and what you're undertaking. And that stayed through right to the end, and it stays through to this day. The Tech Accord is concerned primarily, in this negotiation, we were concerned primarily with the impact on global cybersecurity. And the convention, Budapest has the same lack of explicit protection for cybersecurity researchers that this convention does. But Budapest has an explanatory report that goes on for sort of 60 pages that illustrates what you should not do when implementing the convention. And one of the most fundamental things you should not do is criminalize publicly useful activities that would otherwise fall within the scope of the convention. And journalists, whistleblowers, and security researchers were three of the categories that were listed. We persistently throughout the negotiation said that since this convention would not have an explanatory report, those protections that are in the Budapest explanatory report need to be actually in the convention proper. And unfortunately, we were unsuccessful in winning that argument. There is language on cybersecurity research, which is kind of ironic. It talks about how important it is in a part of the treaty that has no real impact, while not actually protecting them in the operative parts of the treaty. Some of the other provisions that are really serious are that basic business operations can be criminalized because the articles on third-party liability and on participation and attempt have been, one is mostly Budapest and the other is from the Corruption Convention, which of course is an entirely different and specialized purpose. So where Budapest would criminalize aiding and abetting, this convention criminalizes participation of any kind. So you have a payment service, and there's no intent requirement either. So you have a payment service which inadvertently allows a crime, proceeds of crime to be paid for through its service. And technically that service is liable under the articles of the convention. And the convention also has the Corruption Convention's seizure of assets provisions. So technically, you're even subject to having your equipment and the rest subject to seizure. So there's so many examples of this, the scope of the convention, the criminalization articles. One of the ironies that I find still to this day is there's an Article 4, which says that any crime that's articulated in UN conventions and protocols, whatever that may mean, when done via technology should also be criminalized. Well, nobody knows what that means because the UN Secretary General is the depositary for 560 odd conventions. So we don't know, is it all the conventions that he's a depositary for that might have a reference to a crime in it, or is only those which the UN has adopted that this applies to? This was ironically enough designed to solve a political problem, because Russia and friends wanted every kind of content-related crime you can imagine. At one point, China even proposed a fake news crime. And the only way to get rid of all of these things was to come up with fudge. So this is the fudge that they came up with. At no point did anybody actually say, could we actually find out, please, what crimes we are talking about here before we agree to it? The request was never even made to the Secretary to study that subject. But it was politically convenient to agree to it. And so the member states did. So the whole process really, it worked exactly as it was designed. It was meant to be very fast. It was meant to be a rush. to judgment, and that's exactly how it worked out. And we still don't know, even on the eve of adoption, we still don't know, as I said, even what acts it even applies to. And I'm still waiting to hear somebody ask UNODC, what crimes are actually articulated in this body of crimes? And to my knowledge, it's never even been requested.
So what's the industry take on this draft convention? Not that speaking for all industry.
Yeah, I was about to say, I
Perspective.
think my industry colleagues would have things to say about that. So, I mean, first of all, I'll begin very briefly with one positive note, which I'm never one to do, which is that, like, regardless of the criticisms of aspects of the treaty, which Nick just talked about, and I think folks will talk about now, everything would have been much, much, much worse if the UN itself and governments, including the United States, hadn't involved private sector and civil society throughout the negotiating process, right? This could have been a far worse story. And I think, you know, on issues dealing with technology and human rights and law enforcement, that sort of multi-stakeholder participation is, I think, essential. And while I think we have some questions about the mark that we landed on here, I don't think it's in doubt that it would have been much worse without that participation. So we're thankful for the UN and the US and other governments for involving us. You know, Google is a member of a number of industry and trade association groups that have criticized the treaty, the Chamber of Commerce, the International Chamber of Commerce, the US Council for International Business, and others, to name a few. And part of the problem from our perspective is both the four corners of the document itself and the moment in which that document has arrived at our doorstep. There's a provision to give just one example, and then I will shut up, is there's a provision in the UN Convention which by its terms legitimizes efforts by law enforcement to coerce company employees who have access to systems or to data to provide access to law enforcement that are seeking the data in question. Now, one, this is language that is largely mirrors language in Budapest. Two, it is language that if you talk to any cop or prosecutor is self-evident, right? If I can touch you, I can exert jurisdiction over you. And you know, those by themselves, I think a natural reaction is sort of this provision is unremarkable. But the moment in time that we have is a moment where we're companies with a global presence in terms of people and infrastructure like Google, we're increasingly being put in a position where pressure is being applied to us in ways where there's very little notice. There may not be any opportunity to object. We may find out about it after the fact. And this is happening in more jurisdictions than I would like. And so from my perspective, one of the concerns with a document like this is without the context of Budapest and the sort of opportunities to challenge and appeal, without a notice requirement, without that sort of tradition that comes with Budapest in terms of rule of law and due process protections. This is a UN document that is going to make life more difficult for some of our employees in some parts of the world and make it more difficult to operate in some cases. That's a challenge. And so I think from our perspective, I think that's one of the aspects of the treaty that gives us concern. The cybersecurity research provision, which Nick talked about previously, is something we have blogged about and talked about, and is an object of concern as well. But I'll stop there.
And I think before I turn to John, for those of you that don't live and breathe in the UN system, it's kind of a big deal, actually, that stakeholders were allowed in the room and to give statements. So I don't want that point to be lost on those of you that don't do UN meetings. It's kind of ridiculous that it has to be a fight each time, but it is a big deal. I think the administration in the US and others should be commended for making sure that happened. My assumption is that everyone else in the room wasn't like, yay, let everybody else in. So I'm assuming there was a big fight about that too. So some congratulations and kudos to the US and others for letting that happen. But John, what's your reaction to what you've heard so far in terms of some of the concerns that have been raised?
I mean, I'll just kind of address quickly is what I can. I mean, the one about, well, if everybody's saying you're wrong, you have a problem. I lived through this in Budapest. I had to get that ratified, and everybody said that was terrible, and the worst global surveillance convention, and NGOs had. They always have spiders in their graphics. And so there was always a spider. I think it's Web of Surveillance or something like that. So I got lots of spider web pages and documents that said this is terrible. And then, we persisted and we explained and we talked about it. And now Budapest is considered to be, some people, Nick probably wouldn't, but we call it the gold standard in this space and so forth. With respect to the Budapest Explanatory Report, big author, that was my job. So thanks. Things like the publicly useful activities, super interesting point. I don't know what a publicly useful activity is from North Korea's perspective or China's perspective, and exempting that in statutory and convention text would be problematic. We had some good ideas about it, but everybody knew what the explanatory report was in Budapest. It helped explain. It didn't bind countries. So that was I think something to remember from Budapest. The most important thing about Budapest and what we've done over the last 15 years on it, or 20 years on it, close to now, is the Committee of the Parties. That's the place where the work happens and where we interpret what we're doing and what we we call out problems. The United States is not subject to the jurisdiction of the European Court on Human Rights, and a lot of Budapest members aren't. So where issues come up is the Committee of the Parties, and being there, as was mentioned, does help push against the risk of totalitarian states running away with the treaty. Yes, I appreciate. And on 28.4, it's in Budapest. It's basically the same things in Budapest. And, our through line on our negotiations was, Budapest is tested language and it's useful. I understand completely where Will is coming from on that, where Google is coming from on that. We're not happy about the pressure being put on by other countries on their on industry. But I guess my response on that briefly would be, it's really awkward to tell a bunch of middle state countries that it's a good enough power for us, but it's not for you. And so that's not a really sellable argument in a global space. And second of all, I think it's, because it is in Budapest. I mean, it really, as Will said, it is, and second of all, it is something that we want to be supportive of that. The risk is there today. There is no convention, or there's no UN cybercrime convention today. And I understand the point about it being the moment and so forth. But the way to delegitimize this activity is for us to continue to call it out, not to allow a convention that somebody can say, well, this is fine under the UN convention because the United States decided that it didn't want to be part of. And so that's where I would say there's a counter risk. And I'd be concerned about that if I were a global company like Google. They need to have people in a whole bunch of states. So I'll leave it there. I'm sure there'll be other questions. I can make other points, but I don't want to monopolize. Thanks.
Pavlina, what's your perspective on the criticisms that have been made?
Thank you. So I see it from several points of criticality. And one we mentioned in the first question is the context of the convention. It's not the same context for Budapest Convention as at the United Nations Convention. And also, in many years that cybercrime legislation has been developed across countries, we see how easily and how often it's being misused. So naturally, having global cybercrime convention calls into question how it will be implemented and who it will harm. It also has, and you'll hear it over and over again, expansive scope. By expansive scope, we mean not only criminalization, about which I want to speak in this intervention in more detail, but also data access, which has been mostly covered by the private sector speakers. And this is, the broad data access is problematic in this context. But also we see in the provisions on technical capacity and cyber capacity building, how very much intensifies acquiring surveillance technologies, something that a Citizen Lab wrote very well argumented piece for, and something to be watchful about. Surveillance is an important tool for law enforcement, no doubt, but it's also being misused across countries and coming together with weak human rights provisions without any mentions from whom it should be procured. It seems like we are losing the fight on surveillance technologies being used in a manner which does not violate human rights in this treaty. It could have been stronger on these provisions, but still, we ended up with a consensus document. So this reflects the shared understanding in the room that this convention is somehow balanced. As I mentioned, the biggest problems with this convention is scope, and I would like to cover the scope of criminalization, because while it has been apparent in the middle of the 3-year negotiations, somehow more toward the end, that instead of very expensive scope of criminalization, so this is how you define what cybercrime is, because there is no shared single definition for cybercrime. So you define cybercrime across what is the illegal activity or offenses covered by it. And toward the end, it was apparent that it will be narrower on the criminalization offenses, but at the same time, it's going to be broader on the data access. What happened, and it was mentioned in the previous panel, is that apart from some crimes which me covering specifically the gender perspective, such as CSAM and also non-consensual sharing of intimate images, there was strong consensus on this, which can actually have very many benefits if it's applied in and addressed in a sensitive manner. At the same time, we see that under provisions on international cooperation, states agreed to allow evidence to be collected, obtained, and preserved, shared in electronic form for any serious crime, defined as an offense punishable by a maximum deprivation of liberty of at least 4 years. So this is very much expanding the scope, as another provision which is opening it was mentioned before, to other treaties, and there is not enough clarity around what this means for the expansive scope. Considering how much of modern line today is happening online, there will be electronic evidence for almost every serious crime under any domestic legislation. So this is something to be mindful about. And coming from my research in New America on the gender perspective and how cybercrime intersect with it, some activities relating to gender identity, expression, and sexuality, as well as access to and provision of abortion and reproductive health care, are criminalized by domestic legislation in some member states and not in others. So it's very important to put guardrails in the implementation because, for example, in Russia, association with the international LGBT movement can lead to extremist charges. This doesn't happen if it's only one time, it's only an offense or punishable by penalty. But if it's repeated offense, something which is very much legal in our countries, and we fight for these rights, to have them for our citizens. If it's a repeated offense, it constitutes serious crime under which this data sharing and expansive data sharing could be provided through this treaty. So I will leave some points for Ian as well, because he has many. I will only coming also from working on these more cooperative measure and partnerships around cybercrime. I think, but I know that Ian knows more about this and is happy to explore is also how it misses the kind of incentives for something that Budapest Convention implementation that's very likely is building capacity of law enforcement, of prosecutors, and so that how to handle these cases, how to preserve evidence, how to exchange evidence, how to exchange or request evidence on human rights compliant manner in this manner. And it's overly focused in the technical capacities in this treaty, which are covered briefly on like surveillance technologies instead of the positive measures, what we can do cooperatively, learn from each other, actually increase the capacity of those who handle the crimes and who are relying on this convention to prosecute and investigate crime more effectively.
Thanks. So we're going to go to Ian, but after Ian, we're going to open it up to questions. So as you've been listening to all of this, get ready because it's your chance to ask questions of this crowd. So Ian, what's your take on the criticisms that have been made?
Yeah, no, as Nick said, the stakeholder group, which has been very diverse, has been very united in its position. There's been joint letters. There's been all kinds of information sharing, and because of the open and inclusive modalities of the process, I think we were able to have a good impact. I just wanted to kind of focus on a couple of points. Firstly, the serious crimes points that Pavlina was mentioning. This is that evidence can be shared on anything that's deemed a serious crime. One of the points we made throughout this process was that this was an inappropriate copying of another UN treaty, which in this case was the UN Convention Against Transnational Organized Crime, which defines serious crimes of having a prison sentence of 4 years. The reason that that's in that treaty is to trigger international cooperation, but it depends on two other points as well, which is the transnational nature, so happening across borders, and being carried out by an organized criminal group of 3 or more people in a structured group. This convention doesn't have those other two things, and has just taken this threshold of a sentence, which is actually quite dangerous, as Pavlina said, and put it into this treaty, meaning 2 countries with blasphemy, adultery, whatever LGBTQI association, as Pavlina said, that could be triggered under the evidence sharing provisions under this treaty. And this was one of the examples of a kind of neat political compromise taken by the negotiators that hasn't been thought through to implementation. I think the other really negative point about this, the way that the convention has ended up, is that because the risks to human rights were so high, that the voices of victims of cybercrime have not been very prominent in this negotiation. Because actually, the negotiations have been about much more political things rather than cybercrime itself. And actually doing something to support victims of cybercrime has actually been barely discussed at all. And the other thing that I think is the great tragedy of this process is that it will not give the global South countries who wanted the capacity building that they think they're going to get, because it's so ambiguous and unclear and nobody knows what crimes they're talking about. It'll be very difficult, and if it's probably going to be primarily funded by Western donors if any capacity building and technical assistance is going to take place. If there's a general lack of support, then that capacity building won't be forthcoming. The final point I wanted to make is, there's the principles on these things on protecting human rights, freedom of speech, freedom online, security researchers, which obviously all of us in the multi-stakeholder community were supporting. From our perspective, all the research we've done on organized crime more generally is that what you need to have in place in your societies in order to more effectively fight against organised crime is democracy, rule of law, free and open civil society, free media. And unfortunately, through this process, which was supposed to be doing something against crime, we were actually putting at risk some of those key building blocks that we need.
Okay, so now, anyone from the audience have any questions they want to ask? Yes, so if you just introduce who you are, and if there's a particular person that you want to direct a question to, just identify that.
Sure, I'm Robert Young from Global Affairs Canada, from our legal bureau. Lots of comments, but I'm going to restrict myself to one question, which any of you can answer. So, well, first, the comment is I can't help but think of the old anthem from 1971 by the Who. Some people may remember it. It's called "Won't Get Fooled Again." Our legal team covers both cybercrime and the OEWG process. So I think you see where I'm going with this. I think my question to any of you is, part of the argument against an information security or cybersecurity treaty has been that it would be complex, it would be long, it wouldn't be successful because there's a fundamental lack of consensus today at the UN about how international law applies. That argument, and so a treaty making process would be fraught. I think that argument is unfortunately weakened by the relative speed and success that I think you referred to this, Nick, of the cybercrime treaty. What, in your view, is the best response to the argument that now a cybersecurity treaty is closer to being within reach, that the precedent, some will argue, the advocates will argue that we see how easy it is to get a cyber treaty at the UN. We should start right away on a cybersecurity treaty. We have a precedent in terms of process. What's the counter argument to that? Because I think that is those who don't want a cybersecurity treaty are going to have a counter argument to that narrative.
No?
Yep, go ahead.
Thank you for this question. I did mention in my introduction that we definitely see overlaps. We definitely see how Russian diplomacy is using it. And for those sitting in both fora, yes, Russian diplomats and delegation is saying that, look, already before it was actually adopted by the APCO committee on cybercrime, they use this argument on countries didn't want to negotiate, and now they are negotiating cybercrime convention, and now we are going to have cybercrime convention. So we know that across the processes, this will be misused as an argument. And there have been a long circulated idea for cybersecurity convention, which undermines the normative framework, which agreed on norms of voluntary norms of responsible behavior for state behavior, which we are discussing at the first committee at the United Nations, application of international law, confidence building measures, and capacity building around this. And I think like there are three key considerations. One is that, in my personal opinion, I think the appetite for cybercrime convention among non-aligned countries was bigger than there is for cybersecurity convention. Because with cybersecurity, where we are now, it's about implementing the framework. And I know that there are several governments undermining this narrative and saying that unless we have internationally agreed, legally binding commitments in a treaty, it's not sufficient for guiding the policing the behavior of states in cyberspace. It's still very much minority argument, with most of the countries not having appetite for a broad agreement on cybersecurity because there is already negotiated framework. And the point of them is very practical. What are we getting from this kind of fora? What are we getting for our cybersecurity agencies? What are we getting on to develop them? Where is the capacity which we need? So I think what we can do, or states can do, is to be, and I truly believe in this argument, is to be very strong on the leadership there, on proposing a mechanism which would be strong on stakeholder inclusion, because this is where the extra capacity for cybersecurity for countries which are still lacking and seeking it, and that's why they involve in this fora, this is what they need. And by governments who are on one hand saying that we support stakeholder, and on the other hand, when it comes to kind of, decisive situations and speak strongly on behalf of stakeholders, they go down to very watered language on we support stakeholder inclusion under certain vague modalities. Well, this is not how to win the hearts of the community, because there's all the cross-regional understanding that stakeholder inclusion is important. So I do believe by strong leadership, whether it's program of action or any other implementing mechanism, we need to really build narrative around it, how it's going to help those countries who are coming in large numbers to open any working group, seeking more capacity for their national agencies.
Thanks. Okay, well, I think you wanted to answer this as well, and then I saw a hand over here in the corner. I'm sorry, Nick, and that's a hand in the corner.
It's a great question, and you're exactly right. I think this was a strategic mistake to allow this convention to be adopted, unless it was so great that you could portray it as a win for democratic principles and the rest, instead of what it is, which is not that. I think the one saving grace is the process was so bruising and so many developing countries were truly exhausted by it that it will be hard to argue that doing this again really soon is a good idea in terms of the capacity of states to participate in it. And given that it's a peace and security related, this treaty, next one would be a peace and security related treaty. So I think that's the positives. I think that those who believe in the open internet and the rule of law and the rest need to come up with a counter argument for how can states work collectively to improve the state of cybersecurity generally, in spite of those states who are the problem. I think that is work that still needs to be done. I'm working on this myself with some of your colleagues. But no, this has helped Russia. In the end, people will get over being tired. I would bet money that Russia will make a proposal next year or the year after at the latest.
Thanks. As the moderator, I'm just going to use my prerogative, and I'm going to answer this question for you as well. Based on my experience, it's pretty clear to me that this convention was negotiated in silos within government agencies.
Yeah.
So it's pretty clear based on the text that's available and that was agreed to by consensus. And you keep saying consensus. I'm going to say that's consensus of a group that's going to have to go to a broader group that's going to then pull in other agencies. So I would wonder if across Western democracies, there was a fulsome interagency process that was part of their negotiation at every step of the way. I would argue probably not, based on my experience at the Commerce Department as a non-law enforcement person, but that could be why historically we would say it would take too long, because if you run a fulsome interagency process that would have addressed or taken on one by one all of these concerns that would have been part of your delegation, it would have taken a longer time. So that maybe is a different type of answer to your question, if that helps you in any way. But let's go over to the question up here, and then we'll go to Roger in the back.
Thank you. So I have two questions. The first one is speaking militarily, strategic. The second one is operational and tactical. So as per the first one, we have, and I would like to build on the last comment. So we often hear how Russia wants to undermine international liberal order. But Russia has also learned, along with China, that they do not have to leave the United Nations. On the contrary, they're inside. And that's how they're creating a new, they're trying to create a new roles within the United Nations. In April, Russia had a conference on BRICS specifically on information security by creating what they call a multipolar system. And I understand every time when I mention a multipolar system, a lot of people in the West, they are laughing about this, when in fact, it is truly about perception. That's exactly how they're creating. So I would like to hear, any of you can maybe tell us from a strategic perspective, how do you see Russia actually being in the United Nations along with China and undermine this system within? That's the first question. Second question, I would like to ask maybe Nick, because you mentioned this, on information security. If you read Russia's draft, not the English version, the Russian version, they love to use the word information security. And it's not a question of semantics, because as I mentioned, Russian military understands it in a completely different way. They combine both the technical, but also the psychological part. When you read comments, every time after your meetings, they love to talk about digital sovereignty and about how the West is trying to undermine the free flow of information. So I would like to hear also your comments on that, on digital sovereignty, and how they are trying to use this treaty also to underline and create like their psychological operations environment within the treaty.
So who wants to answer the question or take on the question about having Russia and China in the tent and how that undermines the system? I think that's kind of a summation of the question, but John, want to go?
Yeah, I can take a little bit of that. Obviously, I'm a cybercrime guy, not an information security specific, and I'm not in those processes. So I'll leave that to Pavlina and to other people to comment on that. Russia and China, yeah, they are there in the UN. They've been there for a long time, and they're going to continue to be there. And there is no question, I agree with the premise, they are trying to establish a different view. I do disagree that what happened here was a success of that project. It could be a success of that project. We could walk away from this convention, allow them to essentially make it into whatever they want to, and then move on forward through, if we walk away, our like-mindeds walk away, we decide to just, give up this process, the Russians and Chinese will use this, they will amend the convention, they will do protocols, and they have the thin edge of the wedge there. There will be a lot of countries, the same ones that Nick said, we're very tired, that will go, oh, okay, well, this is, a UN convention, this is part of it, so, we'll live with it, it's fine. There are countries, and at least that my view is, those countries just want a convention that they can sign and get some cooperation. Understand Nick's point about, well, it's not good if it doesn't have the West. On the other hand, they will be continuing to look for that. So I guess from my perspective, I do agree that there is an attempt for sort of a different view of how we look at the internet. That's certainly what we heard from Russia throughout the negotiations. Certainly, China kept itself a little bit behind they're even more kind of, Russia is a little bit just blatant about what they want. I think China was a little bit quieter, but they're looking to set the agenda. My view, which probably won't surprise any of you, and I'll shut up after this, is that our only way to kind of push back against that is to continue to engage, to continue to have the US, the EU, and so forth. And just on a quick point, like the concept that we would have been able to block this convention at this level or I just don't see it. Like there was no vote that was going to favor us on this on a 2/3 majority basis. There wasn't. The project is not, if the US were to disassociate itself from this, it would be the US basically doing what Iran did at the end of convention negotiations and, calling a bunch of votes and then banging our shoe on the table and leaving or something. But this convention exists. I mean, if it goes to a vote, it'll get a 2/3 vote. I have no doubt in my mind about that. So this is, you can complain about what happened in 2019. Yeah, I mean, I don't know. That was when this happened. We lost that vote by a lot because Russia had been pushing for this for a long time. And it was successful because this went quickly because we did, we took Budapest, we took UNCAC, we took UNTAC, and they were able to build from that They existed, they weren't gonna not exist. And that was where we went on this. I don't know what would have happened if we had taken, we didn't have as a national strategy or a national plan under this to block, to throw every roadblock we could into the negotiation. That's not how the US tends to operate. In international fora, we tend to engage in good faith and not try to scuttle negotiations. So that's it.
So Nick, do you want to particularly take on information security, and then we'll go to Roger and probably one or two other questions?
Yeah, there's so many dimensions to that question. So this is one object lesson in that approach of how to take a system and turn it into something else, which is their long-term project. The other one is the Pact for the Future, which was just adopted yesterday, which we were talking about earlier, where the very end of this is another tortured negotiation. That Russia calling that vote where it lost 143 votes to 7, they'd been acting like that for 8 months. So the brinksmanship it pays, like they get paid off of this. It works for them. A number of the provisions in what was agreed are watered down, but they were Russia's object. Like I said earlier, it was deliberately to take, they've taken Western systems, used it as a way to disseminate their propaganda, and then they blamed those systems for having that propaganda, and they got countries in the developing world to go along with them. Like it's pretty clever. I mean, I can't you can't fault them. They're good at this. But that is how they approach everything related to the internet, really. I mean, you've seen it. We've been at the same meetings watching them do it. And they play a very long game, and they're very good at it. And I agree with you. They and to a degree, China also. China's similar ideas. They put them in a way which, if you were a reader of it, you go, oh, it sounds very reasonable. And then you go, okay, but you have to think that you're interpreting this with your eyes. Like, this is not what they mean. They don't mean that. They mean this. And then people go, oh, but that's terrible. But this is the thing. It's what's on the page that people agree to. And so they're very carefully putting this together so that it sounds like one thing, but it means something else, and getting countries to buy into it. I should also say, I think you're entirely right, Fiona, about that not always the right people were at the table in government. I was really struck by the makeup of the negotiating teams at the very last meeting, where there were ministries in many delegations who had not been present before, who were coming up to us and going, what the hell is going on here? This is terrible. How do we? And it was then too late to stop the train. So I think that that's true. And I should also point out, for those of you who don't know, Canada and New Zealand carried the torch for a much better instrument tirelessly throughout this negotiation. And some of the most important protections there are in it would not exist without Canada and New Zealand. And at times they were frankly resisted by some of the like-minded states in trying to do the right thing, by states and groups of states who should have known and did know better. And so you really have to be saluted, because you guys just wouldn't give in. And as bad as it is, it would have been much worse if it hadn't been for you.
So why don't we go, Roger, and any other questions? We'll take a couple of questions, 1, 2, and 3. So go ahead, Roger, and then we'll do these other two as well. Go ahead.
Yep. Everything, for those of us who have followed the cybercrime saga at a distance, there's a big gap in understanding how the process has evolved. And some of the panelists have touched on it, but I'm hoping you can make it a little bit more succinct in responding to the question the way I'm going to put it. It seems that between 50 and 100 countries are supporting the convention in the form that it's in now, or something close to it. And that's notwithstanding the avalanche of criticisms that we've heard from the panel today. So in order for us to understand how we are where we are today, I'll put the question this way. if this were a closed meeting of the G77 or BRICS Plus, and you were the Russian representative sitting up there, and you were telling us why this convention is good for you and better than Budapest, what are the 3 reasons that you would give us as to why you should ignore all those people from the civil society and whatnot, ignore those Americans? This is why it's important for you. This is why you benefit. It's not clear. John has mentioned a little bit of it, but if you could just give us like, what are the 3 reasons the Russians are able to get this many countries to support the convention?
Okay, let's take this other question. Go ahead. Yeah, go ahead. Right, yep, go. Mhm.
Chicken Huang from the law school of Wuhan University in China. I think it is easy and interesting to label this convention as a Russia's Trojan force or Russian force. In the meantime, we should also not overlook the fact that the initiative to negotiate the convention was supported by near 100 countries from the global south who have expressed their dissatisfaction with the Budapest Convention even before Russia proposed the 2019 resolution in the UN General Assembly. I think for those countries who supported the convention, the purpose of having this new convention are twofold. One is to solve what I call process-related legitimacy problem of the Budapest Convention, as mentioned by some panelists. Almost all developing countries did not participate in the negotiation of the Budapest Convention, and in that case, for them, the legitimacy of the Budapest Convention was as a potential global standard in fighting cybercrime is doubtful. Although seriously, nobody deny that the Budapest did play an important role in the past years. The second is to solve what I call substance-related effectiveness problem of the Budapest Convention for those countries with the development of new technology and new forms of cybercrime. The Budapest Convention is not that effective in fighting these new forms of crimes. There can be many examples, and I know many are controversial. Just allow me to mention cyberterrorism. At least for quite some countries, not only Russia, not only China, this is a real concern, a real threat to the national security and the stability of the countries, of those countries. And then the next question is, to what extent the UN Convention have solved those problems, the legitimate problem and the effectiveness problem of the Budapest Convention. From the perspective of those countries, I say that for the legitimacy problem, in a sense, yes, because they now have the chance to participate in the negotiation But for the second question of effectiveness program, very thoughtful, because also as many panelists mentioned, but some important provisions in the new convention is somehow copied from the previous convention. So just to in conclusion, if we look at this convention from the perspective of a collective initiative of the global south, or a large part of the global south, not only as an initiative of Russia or certain small number of countries, then we can get some different but also helpful insights. So hope this is what I see the commission. Thank you.
Thanks. I think he actually may have answered your question, Roger. But anyway, last question. Go ahead.
Yeah, so Jim Scheller from Georgetown. I just was curious, is there any instruments or methods we can use in the process of the consideration for ratification, either in the process for the resolution that'll adopt this UN convention, or in the process of ratification, where you can use, reservations, understandings, declarations, perhaps around some kind of a document that maybe defines the crimes and maybe does kind of fix some of these issues, so that in interpretation and application of this convention, this is how it'll be approached. And maybe given the bruising that they've gone through, but to his point about legitimacy, it would be a process to try to get not only the Western on the same page kind of countries, but also get the global South to say, hey, this is an approach that would be helpful in implementing this convention, because there are some holes we can tell you that are going to disincentivize the civil society from being involved in your country. So is that possible? Is that simply not part of the UN process? I just don't know. Yeah.
That's a good question. And I'm going to wrap it up with my last question to all of you, actually. So, because we are going to try to stick on time, so we can get on time. So keeping that question in mind, and Roger's question as well, about how do you convince people this is good, where this is in the time process and where this would be in the deliberative internal US process. There's got to be some deputies meetings that are happening now, next few weeks. What's the US going to do? This is going to come to the General Assembly in some way in October, December timeframe. The US is going to have to actually take a vote, either adopt by consensus as the text was out of the working group, or maybe someone calls for a vote and the US is going to have to vote yes, no, or abstain. Those are usually the options available to you in these negotiations. And the way these deputies meetings work, having done them myself and staffed them before, and actually gotten the Obama administration to walk out of a treaty negotiation, so it can happen. Is this treaty going to go the way of the Law of the Sea Treaty, which was started in 1973 and agreed in 1984, and we still haven't ratified as the United States? Or is it going to be like Budapest, that if the US votes yes, and it can take 5 years, 5 years is quick by congressional time, 5 years to ratify. So if you were headed into the deputies meeting, or more importantly, your boss was, and you had your elevator time, what's your advice to your boss? What's the argument to make in the room? Should the US vote yes, no, or abstain? Or are there other procedural things that can be done to address some of these concerns? And we're going to go just right down the road with that question. So Nick.
Do you want me to answer that, or try also to do something on some of the others?
Some of the others as well if you want, but we're going to do it quick. So I want to get sure.
Yeah, so the answer to that question, I would say, is the best thing to do would be for the US to abstain, and for it to get like-minded states to abstain, to send a signal that ratification is a long-term prospect at best. I think it is, with industry opposing it and civil society opposing it. It's hard to see you get 60 votes in the Senate, even if the stars are aligned, really. And so that would be a reflection of reality. And I think countries would read between the lines and say, we're better off, we want to cooperate, going to join Budapest now, if we would be eligible to do it. I think your scenario is great. I think that's easy. If I was Russia, I would say, well, you should join this thing because you have to do far less and can keep much of it quiet. You don't need to require warrants if you don't want them to get data from providers. You don't need to allow users to ever know that their data has been used handed to foreign governments. You don't need to allow appeals against requests for data because you don't have to have warrants. You can keep your cooperation secret forever between you and any other countries that are willing to keep it secret. So you have all the powers, including expropriation of assets and all the rest, but you don't have to have any of the obligations so that the public would know what you're using the treaty for or how. So it's much friendlier to a state. You have almost total freedom to do whatever you like. And of course you keep it secret, the human rights protections in the treaty where you don't have to worry too much about them, because if it's kept in secret in perpetuity, who's to know what you've requested cooperation on?
Will, what's your take? Yes, no, abstain, and why?
Look, like, it's not my role to say whether the US should,
Not anymore.
how the US should vote. I mean, what I will say is that if you're looking for that kind of guidance, right, you've got the US Chamber saying the US should abstain, the Freedom Online Coalition's advisory network saying the US should vote no. Like there's plenty of that in the ether for folks that want an opinion one way or another. I mean, what I will say is, like, as we've talked about today, like, something is urgently needed to help address the spate of cybercrime going on around the world. So the question in my mind isn't really like, does this provision of this convention hit or miss the mark? But is this going to help law enforcement around the world detect, deter, and investigate cybercrime in a way that's efficient, that's durable, and that's rights respecting? Given the discussion we've had today, I think there's at least a question about that. And so the question is, even if it is possible, it's going to take a lot of time and effort to get right. And the question is the time and effort better spent on that or on Budapest and getting more countries to accede to Budapest, given what we've learned from this process? That's the question I would ask.
John, same question to you.
Okay. I've got to be very clear, since I am with the US government, I'm not speaking in this case for the whole US government or saying what has gone on in the discussion, since I'm actually part of them. But if I were making my recommendations, I would say that we shouldn't break consensus. We should, if it came to a vote, we should vote in favor of the convention text. I think breaking consensus or isolating ourselves by voting no will send a very clear signal to the middle countries and to our adversaries that we are not credible in the implementation of this convention. It will give them the license to modify it, to start pushing it in ways that I think will be ultimately to the detriment of the United States, and will undo the things that we thought that we think are very important. The changes, the human rights innovations that are part of the convention, that aren't part of other conventions, our national interests, and industry. And I think doing so will ultimately inure to our detriment internationally. It'll destroy our credibility in these types of negotiations, and it'll kind of make it, I think, pretty clear that industry is driving the law enforcement train for us, and we will lose, I think, credibility in that space. The question of ratification, as I mentioned, is one for down the line. That is a political question that will be decided by a future president and by a future Senate. But right now, I think it's best to stay with our allies, and that we should vote to join consensus, or if it came to a vote, I think we should vote yes. Thank you.
Thanks. Pavlina, what's your advice to people having to decide?
This document which was adopted by consensus in early August. So coming to General Assembly and voting against would frustrate countries who negotiated this document in a good faith, who want a strong instrument to strengthen global fight against cybercrime. I think that it would undermine the credibility of the negotiating process and the negotiators involved there. And well, it's luckily not up to me to decide. I believe it's not a positive message to send, especially as we discuss how the processes are interconnected. And that would be used as an argument, undermine credibility of countries voting against consensus document across fora, and for other purposes, it would be probably politicized very much. There are, of course, other arguments, and we had a whole panel to discuss other arguments and why maybe vote in favor is not a good move. But that's my very personal opinion. I think that the treaty's effectiveness and whether it will do positive things for the fight against cybercrime depends very much on the implementation and monitoring. And in this, civil society and private companies should not be only watchdogs, but they should be guides. They should be consulted, they should be included, and altogether they should make sure that actually the vulnerable and marginalized groups whose protection should be strengthened by this document have their help and protection extended through the implementation. And yes, I would conclude here.
Thanks. And Ian, what's your advice to the person going into the room to make this decision?
No, thank you. And I mean, I think to use a metaphor, I think we're talking about abstentions or voting no in the Unger process. That's bolting the door after the Trojan horse has bolted. Is that the phrase? Locking the door after it's bolted. I think if that was the position, it should have been done 2 years ago. And it's too late for that now. You can't agree something by consensus in the UN building in August and come back in December and say, actually, we don't like it. And not only is it damaging just because of coherence, and this is my personal opinion, what does Russia say about the West at the UN? Double standards, and this would be exactly playing into a Russian narrative. Also, all those global South countries who do see the potential, who do want this, as the gentleman said, would see this as basically people going back on what's been negotiated in good faith, as Pavlina said. It's not, we've laid out why it's, what the problems are with the convention, but we did that all the way through. And now we're at the end and it's been adopted by consensus. So I think we need to be thinking further ahead than the vote, if there is a vote in December, to implementation and making sure there's strong oversights.
So thank you guys very much. And you've heard from the people directly involved what this topic has been like the last few years. I guess I would just say watch the space and see what happens in the next few months in terms of when it comes to the General Assembly and if it goes forward and how it goes forward, and then what the US and other countries do will be interesting to watch. So thank you very much. And thanks for staying in the spot.